I guess I had already told you that.
Welcome. Thank you so much for joining us today at our Wills Trust and Appetizers seminar. It's an estate planning seminar. It's an educational session. We're going to be here for about 2 hours, hopefully less. But it's going to be interactive. It's going to be engaging, okay? And we're going to learn a lot. My name is Attorney Jumoke Oladapo. Today's topic is how to avoid the three biggest mistakes in estate planning. Your trusted estate planning attorney, Attorney Jumoke Oladapo. And we're from Ivy Law Office. Our office is located at 6305 Ivy Lane, not too far from here. I'm the managing attorney. There I do estate planning. We also do immigration law. So we are experts in both. The best way to make a good use of your time this evening is to please turn off your phone. You deserve this for yourself, and also you deserve this for your loved one. I really appreciate you coming today. I would like to do some disclaimers. It's an educational session. It does not create any personal or attorney-client relationship. When you're discussing or asking questions, please try to keep your personal information out of it because this is on Facebook, Instagram, and all that. This evening, questions can be asked at the end. There's a notebook in your folder or a notepad in your folder with a pen. You can jot down your questions for us to answer at the end. Also, you're going to find in your folder an orange worksheet, something like this. We're going to use it in the course of the session. So I'd like you to please complete it and submit it at the end of the session. Um, while we're going through this seminar, I'll be asking questions like, do you want to keep your family out of court and conflict? If yes, please check the box. That's the third part of that orange worksheet. You check as applicable to you. And the second part is about next steps. If you don't find anything to check in the third box, you probably find something to check in the second box. But at the end of the day, the orange worksheet is important because when you give it to us, we'll have a bonus that I'll talk to you about in a few minutes. So fill and submit your worksheet, and please stay to the end because we're going to give you what we call a golden ticket. Alrighty, so that's sample of the worksheet there. Please fill and submit. And this is it. The golden ticket is a bonus that will give you the opportunity to have a one-to-one complimentary meeting with me as an estate planning attorney, where we'll talk about you, your family, your assets, and what you need to know and do when it comes to planning for the future of yourself, your family, your assets. And also, it's a $750 value. So when you submit your orange worksheet, you get that. To get a free session with me, called the Family Wealth Planning Session. And if you decide as well to book that session, so one thing is to get the coupon, another thing is to book a session. So if you go ahead and book a session this evening, you're going to get a $250 coupon towards any of the services you do with us, which is a wealth plan or a trust plan. So that's a $1,000 coupon gift certificate that we're going to be giving out to help you, take a next step towards planning. So please stay to the end to be able to get this, and remember to submit your worksheet. A little about myself. Me, founder of Ivy Law Office. We've been in business since 2010, serving the community both in immigration and estate planning, and we've helped thousands of people in both areas of law. thankfully, over the years, people have recognized that good work, so we've got a lot of awards, lawyers of distinction, one of the top best immigration lawyers in Maryland, a lot of five-star Google reviews, 5 stars, and we have about 80 real reviews from people. Top attorney and Alvaro, and the personal family lawyer is a license or training and license that I have specific to estate planning. So we do things in a special way. So I learned estate planning to serve people better by becoming a personal family lawyer. So there's some of our materials you see personal family lawyer. It's not family law really, it's about estate planning. That's my family, that's my why. We started estate planning to be able to help our community, first of all, be educated, and second of all, to be able to keep their families out of court and out of conflict in the event of incapacity or death. And those are my why, because as much as possible, we'll want to preserve family assets for them. And second, I don't want to leave a mess for them. So, two of them are adults right now in the university and have a minor child. These are the team at Ivy Law. Myself, Attorney Will, that's Miss Moji in the back, Miss Princess, you met her initially, and Miss Taya. She's not here today, but we all work together as a team to give the best and excellent service that our clients deserve. So I want to ask the question, do you currently have an estate plan? Have you done a power of attorney before, or trust, or a will, or anything like that? Or doing it?
No.
Yeah, no, yes.
No.
So no, okay. So we'll look more into it. We'll explain what they are, and what you need, why you need is going to be brief, but in the planning session, it's going to be more detailed. I wanted to ask, how did you find out about us? Through your daughter. Thank you so much for coming along with them today. Really, really appreciate it. Thank you. So you said no, so why not? Some people are too busy over the years. Some people say they're too young, that when they grow older, and some people say maybe it's too expensive, but I don't know why. But maybe you know your own why. You want to tell me your own why? Why not?
Just hadn't taken the time to do it.
Just busy, not having done it at the time.
I just retired, so when I was working, I just didn't take the time to do it.
Right. Well, that's
Just
it.
hadn't taken the time.
Okay.
Or keep
So-
putting it off and putting it off.
Just
Procrastinate.
procrastinating. It does happen. You're not the only one that happens to, but at least you've taken a good step. Number one, coming into this, but those are good. Some of the reasons why people have not done it. So I think what you said fits into one.
Another reason too might be that you may not have enough assets to even do it.
Yeah, we'll get there. Let me see. So we'll get there. We'll get there soon. And you're right. You're right. But I wanted to say, why are you here today? Okay. And I wanted to make sure that you're here for the right reasons. So if you're here for the total assurance and comfort of knowing that you have people that will, your family members or loved ones, who will be protected, and you'll have assets passed to them, and the peace of mind of knowing that you've done the right thing for your family, then you're here for the right reason.
Right.
Okay. And the next thing is, if you want the peace of mind of knowing that your asset is protected from the government and it's going to the right set of people that you want, and not the people that you don't want, then you're here for the right reason. There's some people that want to save on estate taxes. Unfortunately, we're taxed while we're alive, we're taxed after we're gone. But at least we can save some things for our families rather than giving a lot to the government. If you want to save on taxes, you're here for the right reasons. Self-care is so important, and a lot of people take it for granted. You know how me. This week I had to take some time for self-care. But if you want to make choices, all right, and put them in writing, and make sure that the people, and you choose people to honor those choices you make about your health care or after you're gone, then you're here for the right reasons. Because you may assume people know what you want, but not necessarily. If you have more than one person, then they may have different opinions. So you want to avoid that. You want to put things in writing about how you want to take care of your health. Who do you want to make decisions about your health? If you're here to know more about that, you're here for the right reason. Sometimes, like age, I don't know how to pronounce age. Hair. I don't know, so just figure it out, because I may say hair, H-A-I-R, here, H-E-I-R, that's something that I, so just help me out there. Another thing is this, a lot of people assets are lost to the government, and they don't know. They don't know. When it comes to things like monies that you put in 401ks, money markets, stocks, and things like that, and your family don't really know everything you have. Or bank accounts, maybe you have 5, they know about 2. Something happens to you, it's only what they know that they'll talk about and try to, work on. The others will be lost to the government. In Maryland, there are over $700 million worth of assets in the Department of Unclaimed Properties. And over the years, there's almost like $150 billion worth of assets unclaimed families' wealth. Why? Because people are not financially organized, and people are not letting their loved ones know what they have in case they pass away. So you don't want that to happen to you. You don't want your asset to be one of those lost to the government. And if you're here to learn about how to do that, you're here for the right reason. All right. We've spoken about all this. You're welcome. All righty. So, if you're here for the total assurance of knowing that your family will be taken care of, your assets will be taken care of, you don't want your assets to be lost to the government, you want to make healthcare decisions by yourself and not a stranger making it for you, and all those reasons, you're here for the right reason. Is anyone here for the right reason?
Yes.
Thank
And
you.
now, that big book that they send you every 5 or 10 years and tell you that it's unclaimed property, is that what this is? And
The
people that maybe pass away and they have property that's unclaimed.
yeah, that's part of it. So
Part
that's
of it.
actually the Department of Unclaimed Property in Baltimore.
Mhm.
And you can find out more about it online, also, it's there. So this is another reminder that we should remember to complete our orange worksheets. It's inside our blue folders. I'm going to be asking questions as we go on. Please fill it out and submit it at the end of the, please stay tuned to the end, complete it, submit it, and we have some gift certificates for you. All right. So a lot of people confuse estate planning with real estate.
With probate?
What did you say?
With probate?
With probate?
Yeah.
Yes, exactly. A lot of people confuse that. But estate planning, that's a simple definition. Planning in advance and naming who you want to receive things you own after you die or in the event of incapacity. But that's a simple one. A good estate plan is so much more than that. That's the basic definition. So when you're planning ahead in advance, that's estate planning. To determine what will happen in probate, or if you want to avoid probate. You get it? So probate is after you die. Estate planning is what you do to determine what happens afterwards. And estate planning also includes planning for incapacity while you're alive. All right? So we're going to touch on that as we move on. So some people say they don't have estates. So do you have any estates? Do you have anything showing there? Do you have a car? Do you have some furniture in your home? Do you have a home? Please let me say yes, no, yes, no. Do you have a home? Do you have a checking or saving account? Maybe a money market account? Do you have some investment accounts, like stocks and bonds, maybe? Do you have a 401k retirement account? Do you have a life insurance? Do you have some jewelry?
Yeah.
Some clothes? Some artwork?
Yeah. Actually, all of that.
So we all have estates, no matter how modest it is. So do you have any estates?
Yes.
All righty. So if you have an estate, that means you need to plan in advance. You get it? So why don't people plan? Why do people run away from estate planning? Or why do people procrastinate when it comes to estate planning? This is the number one biggest fear that I find, that I know about, particularly for people that come from where I come from originally, people from Africa. When you talk about, hey, go and do a will, or go and do an estate plan, I'll say, I don't want to die. You know, so that they just put it together that, oh, maybe when I have my will in place today, I'm going to die tomorrow. That's a big myth. No. Planning for it is not going to hasten its occurrence. But you don't know when your it is going to be, so it's better to plan for it before it happens. You get it?
Yeah.
So just debunk that fear. Debunk it. I've had my, I did my estate plan probably like 4 years ago. I'm still alive. And all I'm doing is I'm making reviews as changes are coming up. All right. So myths about estate planning, and you told me about it. Some people say it's for old folks or the seniors. Not really. Some people say I still have plenty of time. That's part of it. I'm still too young. Do you have an estate? Yes. You know, when I found out, I had a 21-year-old daughter that passed away some years back. But then I didn't know about all this. I'd have to go through probate. She had an estate. The PIP. Because she died in an accident. That was her estate.
The personal injury.
Yeah.
Yeah.
Do you understand? And she was 21. Do you understand? So
Yeah.
once you start having assets, or you start having a family, a young family, or you get to a point where you need, you have a car. The minimum that you want to have is you want to have a power of attorney, a healthcare directive, and a will. And we'll get to all that, okay? But it's not for old folks. That's what I'm trying to say. It's for everybody, every adult. Like my 20 years old daughter, I'm doing something for her when she comes on this holiday. Do you understand the she's out? I have something for her already called medical power of attorney, just in case. But then she's an adult now. She needs to sign me something that says, if something happens, this is who I want. You get it? Some people say I don't have enough or I'm not wealthy. I think you mentioned it earlier, but we saw that everybody has something. Am I right? So if you have a modest asset, we'll find out more. In Maryland, there's what they call the small estates, and there's the regular estates. Okay, the small estates is for one person anything under $50,000. For a regular estate, for one person above. If you're a couple, then anything over $100,000, that's a regular estate. So
Excuse me, you said you have a couple that does what?
a couple, as in married people,
Uh-huh.
$100,000 and above constitutes a regular estate.
You mean they make $100,000 or?
If they have
Your
assets,
assets.
Oh,
to-
okay.
if you have assets up to
But don't,
100,000.
isn't it two different estates that would be open? It wouldn't be combined.
It depends. Those are all like legal jargons. But just look at yourself as an individual.
Mhm.
So if you have, as an individual, if you have assets up to $50,000, then small estate. If you have assets over $50,000, regular estate.
Okay.
Okay. But you know that some people have assets as joint.
Mhm.
That's when they're looking at that other side of it. Like joint assets.
Yeah.
If I have a home.
But doesn't I thought the accounts, whoever's a joint holder goes to the other joint, the surviving joint holder.
Yes.
Okay.
Yes, you're right. All right. So if so, I don't have enough is not an excuse. I'm not wealthy is not an excuse. I'm too busy. It's not an excuse. So don't procrastinate because anything can happen anytime, any day. But you want to make sure you don't leave your family or your people in a mess. And you want to make clear directions. All right. And some people say a will resolves everything. Having a will, last will and testament, that's the most popular estate planning document people know. Am I right?
Mhm.
So we find people coming over to say, I need a will, I need a will. And they think when you have a will, it settles everything. But no, it could be more complex. A will may be good for some people. A will may not be enough for some people. Do you understand? So a will does not resolve everything, but is a good starting point. So those are some of the things I want you to think. Thank you for coming today. This is a food for thought. We've gone through what an estate is. We've gone through, do you have an estate? We've gone through the maze and all that. I want you to think, who needs your protection or what needs your protection? Pause for a moment. Help me write it down on a piece of paper. Who needs your protection or what needs your protection? We've spoken about some of the things about the types of estates. Am I right? Let me know when you're done. Can I move on now?
Mhm.
Ready? Who needs your protection? What needs your protection? All right. We're going to get back to that because your why and your who is your motivation. Am I right? To get it done. If you don't know why you're doing what you're doing, then you keep pushing it away. But if you know why you're doing this plan now, then you get it done and you don't want to leave a mess. All right. A lot of people, we've spoken about this, but I want you to think about estate planning, not as planning for death, but a new experience, planning for life. I'm still alive, we're still alive, am I right? And we're making the plan for life now and afterwards. But when you plan, when you do a right, and you make a mindset shift that you're planning for life, you're going to be making empowered decisions and informed decisions. Do you understand? You're not just going to a lawyer that you say, I need a will. I want everything I have to go to my wife. Do you understand what I'm saying? And you said the person will draft something or a boilerplate to go online and take something online and just sign without making informed, understanding decisions. When you do it the right way, you're making informed. You know what you're doing and why you're doing what you're doing. You get it? Also, when you're doing estate plan the right way, you're going to be saving your family thousands of dollars, thousands of dollars, because somehow, some way, first of all, your assets will not be lost to the government. If you do it in the right way, they will know what you have, where it is. They'll know who you want to get what. Am I right? And also, putting proper plans in place and doing some extra stuff will save you on estate taxes. Do you understand? I will understand some more as we go. Assets will not be lost upon death. You're going to protect your family's assets from outsiders, strangers, creditors, and also you'll be getting a lifetime right legal guardians and you'll be making financial choices because you're working with expert attorneys who know what they're doing, and you can come back if something is confusing or if something changes and say, hey, something just changed, how does it affect my plan? Hey, this new law, how does it affect my plan? Hey, I just moved, I just changed my house. I want to put my new house into my trust. Do you understand? So it's not like a transaction, one time, forget it, kind of a thing. You're updating to make sure your plan works when needed. And more importantly, you're keeping your family out of court and out of conflict. All right? You want to make your plan work when your family needs it. That's the essence of planning. You don't want to just make a plan and put it on your shelf, and then 10 years or 20 years time, when something happens to you, it's brought up, then all the provisions, the law has changed, or maybe some of the beneficiaries are gone, or maybe some of the assets are gone. Okay? And I'm going to tell you some. Have you made any plans before? So that I know how to jump ahead.
Somewhat.
Some.
Never executed.
Do you have a plan? No, yes. No. Do you have a plan? No.
That's why we're here.
If you don't have a plan, guess what?
The state makes it
The
for you.
state has a plan for you. And the state's plan for you is called guardianship in case of incapacity in Maryland and probate in the event of death. Okay? And Who knows how loving and kind the state can be? They really have your well wishes at heart. Am I right? The love is so much. Oh, what do they want? They want to get as much and can as much as they get and sit on the hand. So, a wise person doesn't want to make the state to be the ones planning for them. You want to plan for yourself. If you don't plan for yourself, then a stranger judge is going to be making decisions for you. So this is what goes on in the event of probate. All right. So first of all, you're not choosing. If you pass away and you don't have any estate plans in place, everything goes to probate court. You're inviting yourself to court, called probate court. If you pass away with just a will, you are inviting yourself. Actually, you're suing yourself to go to probate court. Do you understand? So, but there are better choices. But what happens? Someone is going to come, someone in your family, all right? Let's say you passed away without any plan, any will, anything. One person, either a child or a spouse, will show up to say we want to open an estate. And now, if you have more than one person and they don't like each other, then you call it for conflict. Am I right? And then they're going to be litigating against each other in court and say, oh, I don't think he should be, I don't think she should be. You don't want that to happen. So you want to plan and write it down. Even if you love both of them or three of them or four of them. Say who you want to administer your estate so that there are no confusions. And when they go there, all those fees, attorney's fees will take theirs, they use attorneys. Executors' fees are there, or personal representative fees. If you have a home, there may be an appraisal, there will be court filing fees. If you owe creditors, you have to pay your creditors. There are bond fees. And by the time you take all those fees, let's say you have $500,000 worth of estate, okay? By the time all those fees are taken, what is left? Slow drops of water for your beneficiaries. Do you understand? There was an estate that was closed that has a $1 million worth of land. $1 million land, okay? By the time that went through probate, the attorney's fees alone was like $37,000. Then the person that was chosen as a personal representative's fees was like $30,000. Okay? Then all the fees came out. At the end of the day, what's left? Do you understand what I'm saying? So it's always better to plan so that the state's plan is not what is implemented for you. Plan well. And having just a will is like filing a lawsuit against yourself with your own money for the benefit of your creditors and for the benefit of others. You don't want that to happen if possible. Okay? For guardianship is an event of incapacity. And what happens in guardianship? Let's say someone gets into a coma or gets some form of disability. Am I right? And you don't have any legal documents saying, I want this person to be making decisions for me. You have to go to the court, and the judge will have to appoint someone to be a guardian over your person and a guardian over your money, property. But the bad thing is that the person the judge will choose may not be the person that you will choose at the end of the day. I know the story of a Barber family. Okay, they have this guy ended up in court. He has a son. He has a son. Then he became incapacitated and has to go through the guardianship court. When he got to the guardianship court, the judge said it's not financially credible. So the judge was not going to appoint him as guardians over the assets and finances. But the judge was willing to appoint him as the guardian over the person to take care of him. Do you understand? And the judge now appointed someone to be someone who is called Mr. Lawyer or Mr. Attorney to be the guardian over his finances. And you know, at $200 an hour, how much it's going to take over the years before he maybe passes away. And it was so bad for this man because now the person in charge of the finances was the one cutting the shot about whether he was going to live in his apartment or move to a smaller apartment or move to a nursing home, or, you know, as his assets, as his money was depleting, the attorney was making like not too good decisions because it was earning his fees. So why do you want a judge to be the one making decisions for you when you can make one upfront in advance by yourself? You don't want that to happen, okay? And guardianship court in Maryland, please, you can come in with your son. Okay. Guardianship court in Maryland is like it will take about 3 months to appear before the judge, okay? And if you have important people, in Maryland, most of them get to guardianship more. In Maryland, probate is public. So when someone passes away, I can go online and see your will, the will. Do you understand? In Maryland, probate takes like 12 to 24 months. And also the cost of probate, like I just explained. If it's possible for you to make better decisions to avoid probate, then you want to. And we'll talk about it some more. All those people, we hear about them, am I right? They got themselves a probate court because they either did not plan properly or did not plan at all. Or something just failed in their plans. Do you understand? When people don't plan, or when you just have a will, and you have children under 18, by the time they become 18, they get an outright distribution of the assets. All right? So I just put those two lady and gentlemen there because I know a guy that his father passed away before he was 21. And when he became at 18 years old, he got $50,000. Okay? It was a lot of money. He decided not to go to school. And at 21, he got $200,000, making $250,000. Am I right? He didn't go to school until he was 30. It wasn't financially responsible. Why? Because so much money was put into his hands at a young age of 18. He's an adult, am I right? But does he know what to do? Let's say you have a life insurance. At least I know people that have $100,000 life insurance, and you have a young child. Once a young child turns, you put your child as a beneficiary, okay? When you put your child as a beneficiary, first of all, they can't have that money until they're 18. Now when they turn 18, they'll give it to them. Go, $100,000. What do you think that child will do? Spend it? On what?
A new car.
A new car. Yeah.
Anything and everything.
Trips.
Trips,
Dinner.
dinner, friends.
Yeah.
All right. So you want to make plans so that your beneficiaries don't get their assets outrightly and unprotected. And they're going to be prayed. They'll be told to do credit card. Am I right? And buy stuffs like that. So go to your worksheet. We've spoken about two things in that orange worksheet today. Do you want to keep your family out of court? If your answer is yes, please check the box, that third section. Tell us about your needs. Or do you need to make sure your kids don't inherit money at 18 years old? If that applies to you, also check that box. Some of the kids may not be financially responsible at 21. You know your child, some 25. Do you understand? I've seen people that said, this child, though maybe an adult, I don't think I can entrust so much to her at this age. So you know your family better and you can know what to do. Do you understand? So it may not just be 18. 18 is just a starting point. So if you don't want your kids to inherit money outrightly, starting at 18 years old, just check that box. Also, lack of proper planning. What may it cost? It can cost love if it's properly done and cooperation. But if it's not done well, if you don't plan at all, or if you try to plan yourself and make a mistake, like, some people try to build up their plans online, I call it DIY, or if you try to use an attorney that is not specialized in estate planning, like I call them traditional lawyers, or they just do everything. In the United States, as an attorney, you shouldn't just do everything, because each aspect of law, it's like so much by itself. So choose 1, 2, 3 maximum. Don't do 10 things. Do you understand? So if you go to a general practitioner that does like everything, they'll tell you they know how to do a will, but they're not necessarily going into the real details. Do you understand? And they may make some errors that an expert or someone who is focused will catch. So those who plan well end up loving each other. Their siblings or their children or their family will be united. But there could be other incidences like this, fighting each other, arguing with each other. Is that what you want after you? No. Divide my house. We have to sell this house and divide the money. Why? Maybe you don't even want your house to be sold. Am I right? Maybe you want the house to be used as an investment for the children, but you didn't tell them, you didn't write it down. But because the love of money is the root of all evil, everybody wants their share. They're like, we have to sell the house. We will divide it into 5. Or the people, most of the time, money will take you to court. Litigation will happen. I've seen instances of children suing the parent in blended families. And by the time you go through litigation, it's going to cost thousands of dollars. So why not plan and avoid those type of instances? Or the child that is entitled. So how well do you know your family? My opinion, there's always a black sheep in the family. There's usually, not always, a black sheep in the family, and you don't know them until it's until it's money matters. So you want to make your plan in such a way that even the black sheep will not try. Do you understand? How many of you have young children under 18? All right. So some people have wills, and in the wills, they nominate guardians. Who knows about nominating guardians for your children? Yeah, thank you. Please, if you have any child under 18, nominate guardians for them. But you know what people do? They nominate guardians in the will. When does the will take effect?
When you
Upon death. Am I right? The thing is that you have to nominate both, I call it short-term or temporary guardians, for while you're still alive in the event of an emergency, and long-term guardians of after you're gone for your children. I have a colleague that knew, this happened, and went to dinner with a husband, left the baby with a nanny at home, a 16-year-old nanny, and she was like, okay, what? Nanny and baby at home, am I right? Husband and wife went to dinner. She was like, what if something happens to the two of us? What will happen to our child? The police will come because they'll see their ID and get their address, am I right? And then they'll ask that 16-years-old nanny, what authority do you have to take care of this child? And at the end of the day, the child is going to end up with CPS. You want to avoid that. How many of you want your children to end up with the government, with the CPS, with foster care? No, I don't want that. So you have to nominate short-term guardians for that are legally authorized and documented to be able to take care of your children or make decisions for them in your absence. There could be people in close proximity to you, and you let them know. We have something called Kids Protection Plan in our office that takes care of all that and much more. So that if such a thing happens, we have an ID with the name of temporary guardian. The call, like the ID is always in your wallet. Am I right? That temporary guardian ID is also in the wallet. So if they're picking it up, they're knowing who to call, and the legal document also that says this person has the authority to take care of my child. So don't take this child to the government. Do you understand what I'm saying? So plan for now, plan for later, plan for emergency. Don't leave your children at risk. 69% of parents have not nominated guardians for their children, but you don't want to be part of those numbers because you love your children so much. So we want to talk again about healthcare directive. Earlier on, so go back to your orange worksheet. I need to name guardians for my children. If you need that, please check that box. All right, if that applies to you, please check that box. All right. I think I missed something out, which is the part of the children's inheritance. Am I right? You can do some extra levels of planning, not only for your children not to inherit at 18, but to be able to have a say about what happens after they're gone. So, for example, I want my child, let's say you have $600,000 to give to a child. You can say, in a trust, I want my child to have let's say 100,000 at 18, 200,000 after in college or after leaving college. When you graduate, you have the remainder. Anything you want, or at 30 years old, have 30%, 60%. At 25 years old, have 20%. At 18 years old, have 20%. You get what I'm saying. A will alone may not afford you that opportunity, but having a trust will afford you that opportunity to say what you want, how you want it, how you want your assets to be distributed or to be managed after you're gone. You're in control if you have a trust. Do you understand? So we'll talk more about that in a bit. So when you have a trust also, because I mentioned it, you can plan in such a way to keep your assets away from creditors, lawsuits, and divorces, household divorces. So let me tell you, for example, if you have a daughter and you pass something across to your daughter, let's say a house, and she decides to sell the house and she sells it for $500,000. Okay? Now she got married. She now kept the $500,000 in an account, probably a joint account, or commingles that. Okay? Now that money is not a marital fund. Okay? It's supposed to be an inheritance, but because people are in love or they don't know how to properly manage things, they now put the inheritance money for family marital problems. Now it's a marital asset. Am I right? So things fall apart and the love faded away. And now they're in the court. All right. That's Mr. Man or Mrs. Woman, whoever it is going to have half of that $500,000 from that parent's house, parent's inheritance. Okay? Could that be what that parents want?
No.
No. But because you not plan, the parent did not plan in detail. Do you understand? That can happen. So if you give your children stuff outrightly and they're not educated to know how to keep their inheritance away from marital assets, they may end up in trouble. Do you understand what I'm saying? Lawsuits, creditors, anything can happen. I have a situation of someone that probably got a house, used the money of the inheritance, kept it in the bank. Then the house flooded. The insurance company came. The insurance money could not cover the damage. At the end of the day, they had to spend inheritance money to clean up the mess. So a lot of things happen, but proper planning can help protect your assets even after you're gone. You understand what I'm saying? Sorry. So if you know that you want to ensure that your children's inheritance is protected from lawsuits, creditors, and future divorces, no matter how old they are, you can check that box for me. All right. So now we're back at healthcare directive. I was speaking about self-care. That this is a part of estate plan that you need to do for while you're alive. All right? Because if you don't make decisions, first about your finances and well-being, and about your health, at the end of the day, a judge will be making those decisions. I know I have a family. Who remembers that? I'm going to go to healthcare first, okay? That's Terry Shivel. You remember our story? it was about in the 90s. She became vegetative, and her husband and her parents were fighting over whether she should be on life support or not. This took 10 years of litigation, 10 years, and thousands and hundreds of thousands of dollars before the Supreme Court could make a decision for her to get out of life support. A simple document called a healthcare directive would have made such a decision. I want my husband to be my healthcare agent, or I want my parent to be my healthcare agent. Simple. Am I right? But she didn't do that. A lot of us haven't done that. If you become ill, incapacitated, coma, stroke, whatever, or even if you're going to surgery, do you understand? A lot of us have go through surgery and we don't have healthcare directives and things. What if? You need to have a healthcare agent so that there won't be conflict of opinions, conflict of interest about whether you want life support or not. If you don't want to, write it down. If you want to, write it down. If you want to say how long, you don't want to put that heavy, sensitive decision on someone else to make for you. Am I communicating? Please. You need a healthcare directive if you don't have one. I was going through colonoscopy a few months ago, and I was completing the intake form, and I saw that, do you have a healthcare directive? I'm like, oh, rap, it's really, really important. Do you understand? And I have my healthcare directive in my health profile. If something happens to me, all I need to go is to go on my health chart, and it's there. And they know who should be making decisions if something happens to me. So we need that if we don't have that. And that's part of estate planning. Also, and if you have one and it's been a long time, you want to update it. So look at your orange worksheet. I need to update or review or make a new healthcare directive. Please check it. If you don't have one, check it. All right. Now, with powers of attorney, you're talking about who's going to be making everyday decisions or financial decisions for you. You understand? I don't know if people still use checks. It's using checks is fading away now. Am I right? But when we used to use checks a lot. If you have an agent that you've authorized to be your power of attorney, the person can sign your check. The person can go to your bank. Am I right? And make transactions on your behalf. You can pay your bills. Am I right? But if you don't have one, it will be difficult if you can't make decisions by yourself anymore. Then they have to go through the court to be nominated as the guardian before they can have access to pay your bills. And probably you would have owed a lot of mortgage companies and all of that. Those are legal documents that are important to have, and they're part of estate planning, and they're so important. I can't overemphasize that. So that in the event of incapacity, we're covered, choosing agents that we want to make decisions for us. And not only that, we're saying what we want. Do you understand? So that they have clarity and directions about how to manage our lives or well-being if we cannot by ourselves. And all those things can be customized if you use an expert estate planning attorney. Now we want to talk about, we spoke earlier on about avoiding probate. Can you remember? Probate is costly. Probate is probably something else that we spoke about. All the things we spoke about, and and all the drinking water. Or you can have a better plan, alternative to probate. You can have an estate plan done in such a way that you can avoid probate court, thereby saving money, preserving your family assets, saving time, and keeping your privacy. And that's through having what we call a fully funded living trust, with disability provisions. Don't try to do this by yourself or online, because a lot of those are boilerplates. And some people want to go cheap and do it online. And after they're done with the online company, you know what the online company tells them? Take it to an attorney to review for you. So I'm like, so why did you do that? And now tell them take it to an attorney. Why? You understand what I'm saying? So just take it to an attorney straight away to help you draft a leave-in trust. But the key word there is fully funded. And you know what fully funded means? Fully funded means you transfer your assets from your name to your name of your leave-in trust. Anything in your personal name takes you to probate. Anything you hold joint goes to the joint surviving person, so both go through probate. Anything you hold not in your name, like in the name of a trust, will not go through probate. Okay? If you have any questions about that, we'll answer it. But fully funded means you're transferring the title, for example, of your home from your personal name to the name of the living trust, so that if you pass away, it's not in your personal name and it's avoiding probate. A lot of people, I said, want to do it cheap. And you know what happens? They can prepare the document for them, but these people refuse to go to the lawyers. And they keep the documents in a folder, beautiful folder, unsigned. And they paid thousands of dollars to get it done. Will that document work for them? Will that living trust work for them? No. Am I right? That's why I say, don't use traditional lawyers. Because you tell them you want to draft, then they'll tell you to go and read 100 pages. Who has time to be reading 100 pages of documents? You understand what I'm saying? You're going to stay there for 2 years. I've had several people come to me that have actually done this, and the lawyer sent it to them, and it wasn't signed. And I'm like, why wasn't it signed? So the lawyer sent it to me to review and did not follow up with me. And how much did you pay? Something thousand. So what's the essence? Do you understand? So it's better for you to work with someone that will make sure it's prepared and it's signed and it's funded. You get what I'm saying? So that it will work. Because if you have it and it's not funded, it will not work when it's needed. And we're looking at a lot of things. We're looking at your investment account. How is it titled? Does it have a beneficiary? We're retitling it as needed. We're looking at all your bank accounts. How is it titled? We're retitling it as needed. We're looking at your homes, your real properties. How is it titled? We're retitling it as needed. Your personal properties, your car, your life insurance. Does it have beneficiaries? Or does it have minor beneficiaries that will still take them to probate? Do you get what I'm saying? One of our personal properties is our cars. Am I right? I realize that you even need to retitle your car to the name of your trust if you don't want it to go through probate. Do you understand? So we look at all these things and we make sure that it's properly done. If you want to go through having a fully funded living trust, and it also have disability provisions to cover instances of incapacity. Do you understand? While you're alive, then it will turn to a will. and become irrevocable after you're gone. So it has that dual power. You use it, it's revocable while you're alive. You can make changes, you can put assets into it, you can make provisions. And once you pass away, it becomes irrevocable. Nobody can make a change on it, and it becomes like a will.
So when does your assets get protected from the predators? Because if it's a
Both while you're alive and after you're gone, depending on what you do.
oh, okay. Because I thought that it was only your assets were only protected when it's irrevocable.
Correct.
Mhm.
Part of it. If it's irrevocable, it's protected. That's like extra planning asset protection. But you know the explanation of keeping your inheritance protected from for your children from loss of creditors and all. That's after you're gone.
Okay, not
Yes,
before.
not before.
Okay.
All right. So if you want to avoid court, if you want to avoid probate, you don't want to just have a will. You want to have a revocable living trust. Okay. And I just want to make it clear. When do you need a will, or when do you need a trust? So this is just a simple illustration of instances of when I say you may need more than a will. A will is a good starting place, a power of attorney, a healthcare directive, all the stuff that's spoken about, or even being financially organized, putting all your assets together so that it's not lost to the government. So, if you have assets or assets over $50,000, you understand? You may need a trust. You may need more than a will. Yeah, may. If you own a home or a real estate, you may need a trust. Okay? Some people, let me tell you what some people do. They'll think putting the title as a joint asset will resolve the problem. Am I right? So, for example, husband and wife, tenants by the entirety, or brother and sister, joint tenants. The example of husband and wife, if one passes away, it doesn't go through probate because it goes automatically to the surviving spouse. Am I right? What if something happens to both of you at the same time? It goes to probate. Do you understand? So you want to think deep and deep to make sure you're properly planning, not just for the passing of one, but what if more than one? Brother and sister. I've seen people that say, "Oh, okay, my mother." I've seen like 2 or 3 people on a deed before, and they have it like tenants in common. And you know what happens? So they say they have three of, let's say it's 3 of them, 1/3, 1/3, 1/3. Am I right? If it's joined, then if one passes away, then it becomes the 2 others. If it's not somehow like not joined the way it's titled, they'll say, okay, I have 50%, you have 30%, up to or 30, 30, 40, something like that. If one passes away, then it goes to the children. Then it becomes like 1616, 1616, 16. Some people just said ridiculous things. They said, don't sell this land, or it should go to my issues. Then it becomes 1 ton, 1 ton, 1 ton, 1 ton, 1 ton. At the end of the day, who's going to have the assets? They just complicate matters. Tenants in common. Anyway, we can think better. If you have minor children, you want to think about having a trust, all right, for the reasons we've spoken about. If you have blended families, you want to think about having a trust. And you know why? I'll give you an example. I know someone that got a home with a spouse. They're married and they bought a home together. Then the husband passed away. Then the house becomes the wife's. Am I right? Now the wife remarried, and then she retitled the home to be hers and the new husband's home. Then she made a will that says everything I have goes to my husband. Everything my husband has goes to me. Meanwhile, she had children from her first marriage. She had 2 children from my first marriage. By the time she was remarrying, she unintentionally excluded her children. Am I right? Because she made a will that says everything I have goes to my new husband. Everything he has goes to me. Now the home she had with her first husband, she's already retitled it. Am I right? Now she passes away. Who owns the home? Husband 2. Is that correct? Husband 2 can decide to do whatever he wants with that home. And you know what husband 2 did? Everything I have, I give to my biological children. So the children of that woman were disinherited. Why? Lack of proper planning. Blended family. Is that what the husband wanted? Maybe not. Maybe not.
He's turning over in his grave.
So, when we have a living trust, we can say how we want our assets to go into generationally, so that we don't disinherit our non-marital children by our lack of proper planning. You get what I said? You understand what I said? You don't want to disinherit some stepchildren because you got married to a new family, except you really want to. You understand? So you can achieve that by having a trust. If you have problem children that have drugs, alcohols, then you want to look at substance abuse and things like that. You want to look at having a trust, so you're not giving them things outrightly when it's going to just be depleted because they're not doing the right things. If you have like special needs children, you want to have a trust. If you have a business, you want to put your business in your trust. A lot of things. So if you fall into any of these categories, you want to be speaking about, am I personally, should I have a trust, or is a will just okay? Do you understand? And we can walk with you to see, okay, this is your situation. This is what I think you need. This is what I think you can do in the meantime. This is what I think you can do later to protect your family from court and conflict, and to protect your assets from being lost, and giving them to who you want, not to who you don't want, and also to keep your house and families out of mess. A lot of people create mess for themselves because they don't plan, and you don't want that to be your story. And don't assume that your children know what you want. They may not know, because those are difficult. Estate planning could be a difficult conversation. Am I right? It could be difficult to talk about estate planning. And if your loved ones don't really know what you want, they'll be doing what they know, and if they don't know what they're doing, then things will be messed up. All right. All the situations you may need a trust. All right. So, who else wants to protect their inheritance completely? Like the idea of making sure that your children don't leave their inheritance to a new spouse or to a lawsuit. Do a better form of planning. Okay? It's easy. Very, not very easy. But we can make it easy for you. All right? Always at the end of the day, and it doesn't cost a lot. The cost of not planning is way, way, way more than the cost of planning in advance. All right? And we can help you achieve it. So, for those who have a lot of assets, I want to briefly talk about the estate tax. If you have a lot of assets, there's what is called, there are different types of taxes after you're gone, okay? There's the estate tax, there's the probate tax, there's the inheritance tax, there's the federal estate tax, there's the state estate tax. So, if you have an asset, for example, in Maryland, over 5 million, then you'll be paying some extra taxes on that. So you want to plan. If you know someone that has some assets that much, they want to plan in their estate plan. They probably have a trust so that they're saving, creating trust and saving to save on estate taxes, preserving their family's wealth. Prince estate tax probably costing some hundreds of thousands of dollars because he had so much and he didn't properly plan. So, how do you get started? We want to make this easy for you, all right? And in our office, we start with what we call a family wealth planning session. Can someone say that with me? Family wealth planning session. It's like a strategy session. It's the one-to-one meetings that you have with an expert estate planning attorney. All right. You come to our office. It's about a 2-hour meeting where we'll talk about you, your assets, your loved ones, what you want, what will happen to you right now if something happens. What will happen to your assets? What will happen to your family? And what you really want.
Is that a free session? Do that?
Can you say that again?
Is that a free session like this is?
So you can get it for free if you submit that orange worksheet. You can get it for $20. Let me say that again. You can get that session for $20 if you submit that orange worksheet. The value of a family wealth planning session, sitting down with an attorney for 2 hours, the value of that session is $750. But we want a lot of people to get educated, to get informed, to know about them and what will happen and see what they can do. So we're giving you that session for $20. And that $20 is basically to secure your appointment. Make an appointment and secure it with $20. And you will get a family wealth planning session without charge. Oh, not without charge, for $20. Okay.
So it'll be $20 for both of us? Or
Yeah, $20 for both of you. Both of you will come.
Yeah.
And yeah. All right.
I got you. I got you.
She's like, "What do I sign up?" That's a good deal.
So one of the things we spoke about earlier is that we don't want our assets to be lost to the government. So one of the things you will achieve by coming to this family wealth planning session, if you complete your intake, we have a big intake and we have a small intake. At least complete the small intake, okay?
Is it online or is
We
it?
will send it to you.
Oh,
We'll provide it to you. If you schedule, we'll contact you, we'll provide you with the intake. So we have the big intake and we have the small intake. If you are patient enough to work on the big intake, you'll be financially organized by the time you come in for the family planning session, and nothing will be lost. If you complete the small intake, you will still be, but it's with less stress. Do you understand? It won't be as much as if you did the real over, but at least complete the small intake. We don't want to stress you.
Yeah, I can't be straight.
You complete the short intake. It's just 2 pages.
Yeah.
All right.
Yeah.
She was like, I don't know, is that $20 with it?
Now, when you want to modify or change something on your
Estate
Trust.
documents.
trust,
Yeah.
is that how is that charged? But
So I'll get to it. Let's get to the question time, and I'm going to answer it because it's an important question. Yeah. So, we start with a family well planning session, and the family well planning session will get you very financially organized. Okay. Also, you'll be able to make informed decisions and empowered decisions by the time you get to the design meeting. Because the family planning session is very educational and personal to you. And you know why you're doing what. And you also get to learn about the levels of planning. And you'll also be able to choose the level of planning that fits your family's need. All right.
Sorry, I have a question about the will. Does it needs to be notarized, right?
Yeah.
Yeah. Okay.
Yeah. It's better to be notarized.
It's better to be notarized.
So you would need a will and a trust to have.
Let's get to questions
Yes.
time. And ask me all
Write
the
this
questions
down.
you want. We still have like 20 minutes or more, about 20 minutes. And I'm almost done, okay? Our fees are flat fees, so there are no surprises, okay? And also you'll know for certainty that your family will expertly guided with love throughout life, and in the event of your incapacity or death, they know they can fall back and contact a lawyer, and the lawyer will be able to help them. Okay? This is just a repetition, but if you use a traditional lawyer, it could be hourly fee. It's a knee-jerk response to, it's a probate experience, and it's just a transaction. But with us, it's a relationship, okay? And you're planning ahead, and you know what you're going to be paying for. Remember, I asked you a question earlier on. What do you want to protect? And who do you want to protect? Can you remember?
Mhm.
After all this conversation that we've had today, can you go back to your notes and see if it's still the same? Or what?
My family, my assets, and my children.
Okay.
And my
Is that what you
grandchildren.
wrote down? All right. It could have even been more. Earlier on, we said, who do you want to protect? And what do you want to protect? Now we are cycling back to that same question.
Mhm.
So if you didn't write it down, you can
Oh,
note it down.
assets and children
All righty.
or child.
So we don't want you to procrastinate. One of the reasons that we discussed earlier on why people don't get this done is because they say, I still have time, I'm too young, I'm too busy, and they just keep on pushing it and pushing it. Like I spoke with someone that was 80 years old the other day, and he was like, let me think about it.
Yeah.
At 80 years old, you still want to be thinking about it? No. I'm just like, so are you thinking about it right now? Please don't procrastinate. You don't want to leave your family at risk. You don't want to leave your assets at risk. For me, who do I want to protect? That's my family. All right. I want to protect my husband. I want to protect my children. I don't want to leave a mess for them. I want things to just go smoothly. I don't want them to go through probate either. All right. That's it for me. So think about your family, your assets. Get it done. So we want to make it easy for you. Please, if you've not completed your orange worksheets, kindly complete it now. And my staff are going to walk around and take it from you and give you the $750 family wealth planning session certificates when you schedule them over there. Okay, so please give it to them before you go. Complete it. All the information are going to be confidential. Please. So, we're giving you two things today. The $750 certificate for the family wealth planning session. And if you schedule a family wealth planning session, we're going to give you another gift certificate for $250. So that's going to be a credit to you if you plan with us. So let's say, for example, your plan is $1,000. You can give us $250. We will give you $250 credit so that you're paying $750, something like that. So you want to make use of this opportunity. It's just to encourage you to get it done so that you don't procrastinate. Alrighty? Who wants the golden ticket? I want the golden ticket. Please make use of the golden ticket. And if you come for the family wealth planning session and you don't think it's for you, it's not an obligation, okay? You're not obliged to sign up, but we want you to pass as much as possible. We want you to, okay? At least you leave empowered, you leave informed, you leave. The minimum is that you be financially organized. You get it? So it's worth it. So how do you do that? Schedule now. Go at the back, sit there. Miss Moji and Miss Princess is waiting for you to give you a date, time, and the certificate. All right? So now we are at the end of our session and we are open to questions. Questions? Did you write down your questions? All right.
Well,
I was asking, why do we need a will and a trust?
Why do you need a will and a trust? Oh, is that your question? A will is, I'll say, is the basic document, okay? A will is needed for after you pass away. It's the basic thing that you give the instruction about who will be your agent and what you want to give to people. So you're giving instructions, clear instructions. But a will take you to probate. So if you have assets that not necessarily will go through probate, you can just have a will. Do you understand? If you have assets under $50,000, you can just have a will. But if you need a trust, you know the table I did? I said you may need a trust and not a will. That's why you may need a trust. Why do you need both? If you have a trust, why do you need a will? The type of will you're having, if you have a trust, is not a simple will. It's a pour over will. So that will, P-O-U-R, over will, you're pouring your trust. That will is referring to your trust. It's saying, I have a revocable living trust. All right. So people, let me tell you what happens. We did a trust for someone, and the person got a new property. The person got a car, and the car was left in the person's personal name and not in the name of the trust. When she wanted to change title, they told her, go and bring your letter of admin. And where do you get a letter of admin from? Probate court. And when you get to probate court, they're going to ask for a will. Am I right? So that will, the Pulver will, is what you're going to present. But when you get there, the will says, I have a trust. Refer to all the terms of my trust. So it's like taking it out of the court's jurisdiction. You've already made a decision in your trust. Do you understand? So it's I have it as a backup.
But-
Just in case, and I'm gonna give you a story. I have it as a backup just in case someone has a trust that is not fully funded. All right. There is a story of a man. He did a trust for $3,000 a long time ago. He was married to an ex-wife and he did not update his trust. At the end of the day, they had to go to court. And they were wondering, why do we have to go to court? Do you understand? But it was because he gave things to the ex-wife and the ex-wife wants that. So he had to go to probate court. Do you understand? And when they got there, they had to present the power of a will and they had to refer back to the trust. And the trust said, well, I gave this to my ex-wife. And she got it. Because he did not update his trust when she became an ex. So life happens. All right? Life happens. The law can change. Yeah, the assets can change. Your beneficiaries can change. So I'm saying this to say that please don't just create an estate plan and put it on your shelf for years. Review it. We say please review it every 3 years. If there's nothing to change, then there's nothing to change. If there is a change to make, we will make the change. And in our office, we review every 3 years. We invite you to come and review your estate plan without charge, and it's in our agreement. Okay, we'll review it for you without charge. If there's no change, then go. It's reviewed, and if there's a change to be made, we'll do it like a la carte.
So with it-
And it's not gonna cost a lot.
So with the 3 years, do we have to contact you or we all set us reminder?
So right now, it's there in your contract that you contact us. Okay, but we contact our clients regularly.
Okay.
All right. So the people that are 3 years with us already, they know that they're supposed. We called them already and we told them,
Okay.
hey, it's 3 years. Come
Okay.
on. Some people are come. So our office is relationship based. So one of the advantages you get as a client is that we call you 1 time or 2 times a year. We check on you. We want to know that you're good. We want to know that there hasn't been any substantial change in your life that may affect your estate plan. So, and we want to keep in touch with you because you're not just a file with us and you're not just a transaction with us. So, that's all. All right, next question.
So I have a question about the pour over will. So if it goes through probate, so like the scenario you just said about the vehicle. So the vehicle is still going through probate, and then at the end of distribution, it pours over into your will. I mean, into your trust.
So, there is a document in the trust that actually says assignment of personal properties, that you're assigning all your personal properties into your trust.
Mhm.
Okay. Your vehicle is a personal property.
Mhm.
So automatically it should have gone into your trust.
Yes.
But when MVA is saying that
They
that
want the letter
title,
of admin. Yeah.
that title is not in the name of your trust, that's what took it to probate. But then that pour over will is what that person will have to take to the probate court
Mm-hmm.
to be able to get a letter of admin to take to MVA.
Oh, okay.
You
So
get
they
it?
just get a letter of admin, and it doesn't actually go through the probate process.
Yeah.
Oh, okay.
Okay. Next question. You
I
had a
had,
question.
I had questions, but you covered them all.
Okay.
And,
Okay.
the,
Has this been a great session for everybody? Have you learned something? Thank you so much for coming. Thank you so much. Yeah.
Can you go back? You said something about nominating guardians. Am I saying that right? Can you talk a bit about that? Because I hadn't heard that before.
All right. Nominating legal guardians for your children. if you have minor children, if something happens to you, you know you have legal authority, fiscal custody, legal custody, and all that stuff. Somebody has legal authority over the children, and that's the parent. Am I right? If you're not available, or if something happens to you, you want to name other people to be guardians over your children. As a name, it could be your spouse, it could be your brother or mother, or do you understand? Nominate someone, short-term guardian and long-term guardian, in the trust or will. The short-term guardian is in the event of an emergency. I don't want my child to end up in CPS or foster care. Do you understand? The long-term guardians is in the event of death. This is where who I want to take care of my child, and this is how I want my child to be taken care of. And you're choosing people so that the court is not the one choosing someone for you. There's a story of someone that they were traveling from Maryland to Florida. They had a car accident. The parents died. The two children survived. At the end of the day, they were able to get a family member after a lot of, they live in Maryland, they passed away in Florida. They located a family member that is a sister, okay? The children stayed with the sister, and the sister was very dominating of them. The sister wanted to have custody of them and excluded the other family members from seeing them and all that. What happened? The other family members took her to court and said, you cannot be the guardian of this. We don't want you to have custody of these children. We know you, but why does she want to be the custodian of the children? Not because she really wanted to take care of the children, but because of the money. Do you understand? At the end of the day, there was litigation. There was $100,000 litigation that went into it. And the court nominated someone else, another sister, to be the guardian of the children. Because what the court's looking at, what is in the best interest of the child. But if you as a parent, you already know who you want, whether it's your rich doctor sister or your poor teacher sister, who do you want to take care of your child? You would have chosen. And who do you think the judge will choose? A rich doctor sister?
Best interest.
But the judge doesn't know your interest. Do you understand? So that's why you want to choose a guardian, nominate a guardian for your children, so that the judge doesn't nominate one for you.
And the guardian can be different from the person who, I guess, is in charge of your assets or money.
Yes, it doesn't have to be the same person.
But you put that in the trust or in the will?
There is a legal packet that we create called Kids Protection Plan that takes care of that. Even if things end up going to court, the judge knows what you want. You understand? Does any other person have any question? And are we going to wrap up now?
What's the best time to set an appointment?
Now.
For to talk, to come before.
Now, we have dates. We have some open dates. It's not it's limited. It's not like a lot. So you want to choose your date.
This year or?
It could be this year. It could be next year. I think it's a few dates this year, very few this year, then more next year. We can choose a date and time. There's some available, and the dates are open there.
I'd rather choose something that's early next year.
Yeah, you can.
Get something.
You can. Over there, we have dates and time slots available. And so choose it. Look at your calendar and choose something that will work for you. Thank you very much, everybody.
Thank you.
Thank you. Good to see you. I really appreciate you coming out today to spend this time with us. And you're doing this for yourself, for your family.
A lot of people don't know about this, and we're never taught it, and so it just goes on from generation to generation.
Exactly. We have one more session tomorrow at 1 p.m. here. So if you know someone that needs to hear about this, please invite them to come. When they come, they'll register.
It's the same information,
What?
the
No.
same information.
The same information. Yeah. Thank you.
Thank you.
Please submit your orange worksheet and get
Oh, it's Friday, you can bring it.
Uh-uh.